Good morning, everyone. I'm Mark Bronson, President of the Texas Board of Chiropractic Examiners, abbreviated as TBCE and referred to simply as the Board. I am calling this meeting to order. The date is May 28th, 2026, and the time is 9:02 a.m. Please join me in honoring our American flag, followed immediately by our Texas flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to the Texas, one state, one and indivisible. Thank you, everyone. Our board secretary, Dr. Michael Henry, to my left, will call the roll.
Internet's not working for my notes. Sorry, my internet's not running. Will you
I'm gonna help you out.
Sorry, folks, bear with me. I'm having some technical difficulties pulling up my notes here. There we are.
Okay.
All right, we're just going to go from memory here. Dr. Sarah Abraham.
Here.
Dr. Matthew Mix. Dr. Mindy Neal.
Present.
Dr. Michael Henry, myself present. Dr. Mark Bronson.
Here.
Dr. Scott Wofford.
Here.
Mr. Joshua Hullab.
He's parking.
All right, Dr. Nicholas Bockham.
Here.
And Miss Shelley Gardner. Okay. We have a quorum of 7 here, I believe, and one more who is parking, and we can move forward.
Is it 7 or 6? Let's see. So, is Shelley Gardner virtual? She's
No,
not
no.
participating.
Okay.
No.
So it's just
6. Yeah.
6 then. So,
Okay.
yeah.
Thank you.
Still at 1.
Okay. Thank you.
So, of our 9-member board, we have 6 members present today, with 3 members absent. I affirm that a quorum is established. Fellow board members, Dr. Mix notified me and Dr. Bush asking to be excused from this meeting for reason of traveling out of state. I didn't ask for any clarification. I'm not opposed to this request, so I'll entertain a motion to grant Dr. Mix an excused absence.
So move.
Second. Dr. Bockham moved and Dr. Abraham seconded. All in favor say aye.
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 Aye. Any opposed, nay. Motion carries to grant Dr. Mix an excused absence.
Extra one,
Ms. Shelley Gardner also notified me that she would be unable to attend and offered to attend virtually if that were possible, and we were unable to make that happen. So I'll move that we excuse her absence.
Second.
Second was made by Dr. Bockham. All in favor, aye.
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 Any opposed, nay. Motion carries. And I understand Mr. Hollab is on his way. Before we move forward, I want to set the tone of this meeting and put our agenda in context and focus by reading our mission statement. The mission of the Texas Board of Chiropractic Examiners is to execute the statutory authority of the Texas Occupations Code, Chapter 201, and to promote, preserve, and protect the health, safety, and welfare of the people of Texas by licensing skilled professionals and enforcing standards of practice. Honorable board members and Team TBCE, thank you for your ongoing service and for preparing your reports for this meeting. Guests and stakeholders, welcome. Our agenda includes a place for you to share your concerns or advice. Agenda item number 6 allows for public comments, and I'll consider your requests individually and either invite you to speak at that time, or I might ask you to wait until we reach our agenda item corresponding to your concern. As chairman of this meeting, I reserve the right to alter the order of the agenda. At this time, I don't anticipate doing so. Agenda item number 2 calls for discussion and action to approve the minutes for the board meetings held on February 2nd, 2026 and April 16th, 2026. Does any board member require discussion?
I'll make that motion to approve.
So Dr. Wofford made a motion to approve the minutes for the board meetings of February 2nd, 2026 and April 16th, 2026. And it was seconded by Dr. Neal. All in favor, say aye.
Aye.
Aye. Any opposed, nay. Motion carries. Agenda item number 3 is the President's report. Give me a moment, please. So events since that February board meeting, the FCLB and NBCE annual meeting was held in Atlanta. I attended, Dr. Bush attended, Jennifer Hartzenberg attended, and Rudy Calderon attended. Thank you for doing so, everybody. I was the delegate and voted as you directed me to do so during those meetings on May 15th to the 17th. Just a couple of weeks ago was the NBCE Part 4 administration at Parker University, where I served as chief examiner for the last time. That was the last time that the test will be administered on school campuses, and that concludes my service. That's all I have for now. Any questions, anybody? Agenda item number 4 calls for board committee reports. Committee chairs, when I call on you, please acknowledge your committee members and summarize your activities. Dr. Michael Henry, chair of the Rules Committee.
Yeah, hello. So our Rules Committee consists of myself, Dr. Nick Backham, Ms. Shelley Gardner, and Dr. Mark Bronson. We met March 10th to discuss progress on the rules that are moving through the proposal and approval process by the governor's office, as well as to draft and review rules that we were hoping to propose in the future. There were no public comments to review at that time for any rules that had already been proposed. We had several rules up today for proposal that we're going to need some discussion time. This is the first time a lot of our board members have seen those, so we wanted to get some feedback from you guys on some of these before we take any action. That's the committee report.
Thank you, Dr. Henry. Dr. Nicholas Balcom is chairman of our enforcement committee.
Thank you, Dr. Bronson. We, enforcement, met, and that's myself and Mr. Holub and Dr. Neal. We met on April 27th. This was the first time that we've done it. We changed it to where we meet a month prior to the meeting so that we have a chance for the legal team to do their magic and get agreed orders in place to try to accelerate the closure date. It was a long meeting. We did 40 cases, which was substantial for what we normally do. And yeah, everything with enforcement's going great. I'll kind of let Chris go over more in his report. We also have kicked back up with the informal conferences. We had a couple of them about a month ago, I guess, and then we also have informal conferences today after the meeting, so when we all get to go home, we're here until 4 o'clock doing informal conferences. So, yeah, that's my report.
I will comment for the record that Mr. Joshua Holub is now in attendance. Welcome.
Thanks,
back.
sir. Good to be here. Sorry I'm late.
And so thank you, Dr. Balcom, Dr. Neal, and Mr. Holub for your service on the enforcement committee. And that moves us to, oh, by the way, any questions or comments for Dr. Balcom before I move on? The Education Standards Committee is chaired by Dr. Scott Wofford.
So the last 3 quarters, we've had 8 applications. Dr. Neal and Dr. Abraham are on the committee with myself. We've had 8 applications. We've had 6 approvals, 2 denials. The denials were basically for seminars that honestly didn't pertain to chiropractic and not even healthcare, but and one of them quite out of scope. So, but the other 6 were approved. So that's all we have at this time.
Thank you, Dr. Wofford. The chairman of our licensing committee is Mr. Joshua Holub.
You, I'm sorry. We haven't had a thing to meet on, so.
Okay. Thank you, Mr. Holub, along with Dr. Mix and Dr. Wofford, who are on the licensing committee. Thank you for your service. Agenda item number 5 calls for reports from our executive director and agency staff. First, I call on Dr. Bush for his executive director report.
Thank you, Dr. Bronson. I appreciate it. First off, I will warn you ahead of time, I'm fresh off vacation, so if I've got a glow about me and have this distant look in my eyes, you'll know why. But we're back here rocking and rolling with everything, so I'm excited. The bulk of my report is going to fall on Senate Bill 1188. Senate Bill 1188 spells out that certain requirements are needed on the protection of data that you guys keep up with in your practices. And I've got it listed 2 ways. If you can pull up I've got a letter, kind of a full overview of all the details that go along with it. It's titled Important Regulatory Update in the Electronic Health. I want to really focus down on the bottom parts. It's key takeaways for your practice. And in this, we are going to have to address how the board will address this. And so that's going to be upcoming conversations that we have going forward. That's why I want to lay it all out to make sure that we're all on the same page as we move forward. So if you look at the key takeaways, only U.S. data storage. Basically, everyone is required that your patient data is kept in a physical server in the United States. It can't be stood up in the cloud in the United States that's actually hosted in another country. How we're going to trace that is something we've got to determine and see the full extent of what we're going to be doing with this. So, but be aware that the legislators are very adamant that this takes place. DIR is involved with the conversations on how we can verify, number one, our information is kept appropriately, and therefore it will reach out to there. So that's very prominent. So how this all falls out will absolutely take place in the legislative session coming before us. So be prepared. I'm keeping a very close eye on what's taking place that way. So it's very important. Second thing is strict access control. Access to data that you keep is going to need to be carefully restricted and controlled. Only certain folks, and there's more detail in the rest of the breakdown on how this works, but it's good. Certain people will only have access to certain data, so we've got to be very careful about that. So what it's going to wind up doing is, in each practice, you'll have to look at the way that you have patient access to patient records, who's involved, and so forth. And that's why I'm going to be taking this information and adding it to our newsletter that goes out, so it's a broader transition of what's going. I'm going to tell more people that are. Boy, my words are still on vacation too. I apologize. AI diagnosis and disclosure. AI tools to assist with patient diagnosis or treatment recommendations. All of those kind of things must be explicitly shared with your patients. If that's what you're doing, how it works, and so forth. So that's important that we address these needs to make sure, again, we don't have clear instructions on exactly how we're going to do that, so I'm in the process of trying to ascertain that and talk with appropriate folks to make sure that we get it covered the way we need to, so that I can share that information with you and you are going to be informed. This one I'm going to read directly. Parental access rights. Your system must allow a minor's parents, managing conservator, or legal guardian complete and unrestricted access to the minor's EHR immediately upon request, unless restricted by a specific court order or federal law. We've all heard stories about parents and legal guardians not having access to their children's or wards' information. The legislature sought to change that, and so as a result, now it is mandated in the SB 1188. And so it's very important that we all look at this together and make sure we're following those rules. Prohibited data fields. You are strictly forbidden from collecting, storing, or sharing a patient's credit score or voter registration status within your EHR platform. There have been instances also where children have been asked if there are guns present in the homes, and that's an issue that they're still debating on how they're going to address that. So these are very touchy, very issues that are prominent discussions taking place across the street, but I want you guys to understand that that's what's taking place, that it's there. Biological sex fields. EHR system must contain a dedicated field for biological sex at birth. This field cannot be amended unless correcting a clerical error or documenting a diagnosed sexual development disorder. So again, you see the trend we're having in SB 1188, that they're really cracking down on what's collected. Then metabolic health tracking systems must include options to log and to communicate with other healthcare providers regarding a patient's metabolic health and diet for long-term chronic disease management. So this bill is very strict and inclusive, has a lot of detail. That's why we're going to start with me publishing this in our newsletter here in roughly a month after when we get it out. And then we're going to be working on how we monitor that as a board moving forward, giving our perspective on how it's going to be taking place. And so I'm sure there'll be a component to it that we'll try to get some feedback, try to really work a process that's going to be beneficial for everyone. It's kind of the high level view of it. Are there questions? You guys got some concerns?
Dr. Bush, I appreciate you planning to publish these issues that require our guidance.
Yes.
In newsletter. Would this also be something that a guidance document would parallel that?
I would highly recommend it, yes. But it's going to require stakeholder input, board discussion, all of that kind of stuff. So there'll be a process that we need to go through.
So an article in the newsletter is...
It's just feeding
That's the
information
first thing.
saying, this is the first step, this is what's going on, and then we move forward from there.
Okay. Right. For the record, Dr. Neal stepped out. Dr. Neal is back. Thank you. welcome back.
Any other questions you have on just this particular part of my report? Moving forward, part 2. FCLB annual conference. Again, Dr. Bronson alluded to that we went to that. In your board materials, there's a letter from FCLB to the governor thanking him for allowing us to go to that and some of the things involved with it. Just an information piece is all it is. And we had a very eventful conference and lots of discussion. We got to visit with a lot of people involved based upon what our special board meeting made our determination that we were going to vote against the merger, but the merger went ahead and that was voted in an affirmative manner, and now the two organizations have been merged. And so how that will look going forward, how we will represent and be involved with it is another matter of lots of discussion, and we're going to have to make sure and analyze and visit with people that are involved with those decisions. So make sure we do things appropriately as a board. Questions on that? Or other comments, Dr. Bronson or anybody?
I don't have any other comments. Thank you for sharing that information with everyone.
And then the last thing on my list to deal with is we've successfully transitioned the newsletter. We have had our first article from Dr. Vanessa Morales, and it was a very informative, for me especially, informative article, and I was very glad to see it. So we're trying to expand our connection and involvement. We want this to be a community of sharing information together, and so no more just a simple board report. We want to really enhance what we're doing as well, and so it went over real well. I've had great comments about it, and we're looking forward to more and more contributions as we go forward. So,
I like that. It's a great addition to the newsletter.
yes, yeah, and so it shows that we're trying to embrace everybody this way. And that's the report I have for you today. Are there other questions? Anything else I need to address?
No, thank you, Dr. Bush,
Thank
for
you,
your
Dr.
report.
Bronson.
And Mrs. Jennifer Hartzenberg, our Director of Operations, you have the floor, ma'am.
All right, good morning, board members. Attached in your materials is a snapshot of our balances through May 14th of 2026. The end of May will take us through our third quarter, and as we enter into June, we'll be going into our fourth quarter, and we will wrap up our fiscal year at the end of August. We are on track with our revenues and expenditures, and I'll be happy to answer any questions if anyone has any.
Thank you, Ms. Hartzenberg. Next up, Ms. Sarah Matthews, our Director of Licensing. You have the floor.
Thank you, Dr. Bronson. Good morning, members. In your packet, the licensing dashboard shows the stats for the second quarter of fiscal year 2026. Licensing has remained busy as usual. On April 16th, Christopher Walling and I traveled to Texas Chiropractic College for the Tri-9 presentation. That was the first time that Walling came with me, and we had a lot of questions for him, and they were very happy that he was there. Other than that, that's all I have to report. I'd be happy to answer any questions.
Just wondering, does Mr. Walling have anything to add to that? Any insights? No.
It was good, though. It was very, I think that was something good that happened there. A lot of good questions came up.
Thank you for your report, Ms. Matthews, and thank you for participating in that event, you and Mr. Walling. Now you have the floor. Mr. Chris Walling is our Director of Enforcement.
Thank you, Board, for having me today. Report on what we have last done since our last board meeting. My team has been extremely busy. They did an excellent job. Very proud of them. From December 29th, 2025 through April the 14th, 2026, we took in 76 complaints, administratively closed 32 of those complaints. We still have 18 pending with law enforcement. We issued 1 cease and desist order, and we've issued over 6 citations, administration citations that were minor violations. As this board EC enforcement committee meeting met on April the 27th, we presented 39 cases. Out of those 39 cases, we had 17 no violations, and we had 22 violations that we found. In that process, our standard of care, Dr. Janet Herman, the director of chiropractic, assisted in 18 of those cases with her standard of care reviews, which is very valuable to us. We appreciate her very much. She's opened up a lot of insight for my investigators as well as myself on the practice of chiropractic and how things work. Right as currently we stand, we have 136 open cases. 66 of those are currently being investigated by our investigators, and 70 right now stand with legal or disciplinary actions. Top 3 violations. We've actually curbed on the advertisement. We don't see advertisement as much, but it does poke its head up. But right now, billing violations have been our number 1 problem. There's some billing mistakes or excessive billing, improper billing, things like that. Patient record violations is still a problem. A lot of Audubon's not here today, but during some of the classes that I speak at, it's still you can teach and people still don't understand it. It's 15 business days to get your patient records when they're requested. That's still an issue out there. And then standard of care violations, which is a broad spectrum of violations, anywhere from injuring a patient to handling the patient to record keeping or however they handle the patient. But that's kind of a broad spectrum, but that's what we're seeing. That's all I have to report. If you have any questions, please ask. I'd be more than glad to answer.
Are the main issues with records violations just getting records out on time?
Yes, sir.
I guess I'll add to that though. On standard of care though too, with the records, a lot of times the standard of care is poor record keeping.
Yeah.
So that's a big chunk of the of that as well.
Sure.
Okay, board members, any other questions for Mr. Walling? Thank you for your report and for your service.
Thank you, sir.
Agenda item number 6 is reserved for public comments. The board will now entertain general comments from the public on matters not listed elsewhere in this agenda. Your comments are important to us, so please share your concerns openly. Understanding that a 3-minute presentation is customary, as I mentioned earlier, if your comment corresponds to an item on our agenda, we'd prefer to hear from you during our discussion on that topic. And I do have, I've got 3 public registration forms here in front of me. The one on top is Dr. Scott Kelly, and you did want to speak during agenda items 19, 15, and 17, is that right? Or is that a 14? Okay, 14, 15, and 17. So thank you for putting that in order. And so make sure.
I did have a general comment I may potentially have for 14, 15, and 17. It's not likely, but
You're welcome to come up and present that to us now if you would like.
please.
Just state your name for the record and.
All right, well, good. My name is Dr. Scott Kelly, representing myself and the Chiropractic Society of Texas. I have a general comment. It's regarding the recent merger of the FCLB and the NPCE. Prior to that comment, I did want to express extreme thanks to this board. Over the last couple of months leading up to the vote on April 30th, I attended a number of other states' boards meetings. And how you guys run a meeting is just top notch. The time frame of it, everything like that is, I now see that it is greatly appreciated. Further, recently in Connecticut, public comment was outright ignored on the agenda. It was on the agenda and outright ignored, and it was regarding the upcoming merger. And so public comment was not allowed at 2 of their meetings, their past meetings. So again, I really appreciate you guys allowing us this opportunity to insert input. So again, thank you for that. Regarding my comment, here addressing 2 concerns, the legitimacy of the vote that occurred in Atlanta on April 30th, and the effect of that vote for this board ongoing relationship with the NBC and FCLB programs, regardless of how the legitimacy is questioned of that vote. On the vote, FCLB article within their bylaws, Article 16, requires that 2/3 of delegates duly registered and present. With 33 registered delegates, that threshold would be 22. The vote was announced at passing 23-7, but as many as 15 delegates left their paddles on the table without voting. The parliamentarian ruled during the session that abstentions count towards the required threshold. The chair then ruled during the session that abstentions count, the chair then solicited only yes and no votes. Abstentions were never called. A delegate who raised his paddle and abstained was not counted. Nevada, a registered member state, was not called on in the roll call at all. The registered Connecticut delegate did not answer the roll call. A substitute voted in his place without listing alternate on file. So no state-by-state vote record was kept. The parliamentary privately acknowledged to a witness the following day that the vote mechanism was flawed. Board members who were present corroborate all of this. As far as this board is concerned, in our opinion, with ongoing programs, whatever the view the board takes on the vote's legitimacy, the merger has materially changed the governance of every program the board relies on. NBC now owns Sinbad, PACE, RCSP, and EVAS, in addition to administrating the examinations that our statute requires for licensure. The board was a member of the FCLB, and we're not sure how this plays out with the board now being a member of the NBCE. So in potentially having no governance rights over any of these programs in the surviving entity. Part 4 centralization was not subject to public comment. As far as the NBC is concerned, we were not able to have any put back on the centralization of Part 4, which is extremely concerning, as I've presented previously. I won't go any more on that. So we're asking the board to request formal delegate report, preserve all communications received from the NBC and FCLB, and I know you guys do this greatly, and I do appreciate that. Seek formal opinion of the AG on the delegate authority and the board's ongoing product relationships. So again, that is our comments on the recent merger. 2 more very brief comments. There is a bill actually in New Hampshire sitting on the governor's desk that will remove Part 4 as a requirement for licensure. They're not replacing it, they're not doing an alternate, they're outright removing it from statutes. We're going to be seeking that here in Texas after that is signed by the governor, hopefully within the next couple weeks. But it has made it through both House and Senate unanimously. And also, something we've talked about before is the IACE as an alternate accrediting agency is now written into rules and regulations in South Carolina as of 2 weeks ago. So they are now recognizing the IACE in their rules and regs. And again, I really appreciate your guys' time. Thank you so much.
Well, thank you for that valuable information, and appreciate your time as well. And you will have an opportunity to come up and speak again on during agenda items 14, 15, and 17. Let's see. And Dr. Celia McGuire with Parker University College of Chiropractic, you wanted to speak regarding TAC 72.3. What agenda item number is that? Is that
17.
17.
agenda item 17? Remind me, okay, just in case I don't look at you. And then I have a registration form from Forrest W. Voss. And
Mistake.
excuse me?
I'm here to meet you guys to get licensed.
Yeah.
I saw somebody else fill that.
It is agenda item.
Hey, you might as well fill it out, right?
Yeah.
Okay, there's a form, let's just fill it out and sign it. Okay, thank you. So we'll be hearing from you during that item, okay? Agenda item number 7 involves requests to sit for the Texas jurisprudence examination pursuant to Texas Occupations Code 201.304A2, or requests for the issuance of a criminal history evaluation letter pursuant to Texas Occupations Code 53.102 and 22 TAC 72.12. We have one for this meeting. So in a moment, I'll call upon our Director of Licensing, Sarah Matthews, to introduce that request. And then, so board members, following any discussion, then I'll entertain a motion and a second, and we'll vote. Ms. Matthews.
Thank you, Dr. Bronson. That's loud.
That's okay. Some of us appreciate the volume.
There you go.
Agenda item 7A is a consideration request for approval to sit for the Texas jurisprudence exam for Forrest Voss. Mr. Voss is requesting approval to sit for the Texas jurisprudence exam. He was previously licensed as a chiropractor in Colorado, Massachusetts, Wyoming, Pennsylvania, and Washington. He has no disciplinary actions taken against him in any of those states. Mr. Voss previously served in the U.S. Air Force as a special tactics fighter pilot. Mr. Voss previously appeared before the full board on August 19th, 2021, and received approval to take the jurisprudence exam after successful completion of the NBCE spec exam. Due to some financial setbacks related to the COVID pandemic, he was not able to complete this requirement. Applicant has a total of 1 arrest and 1 conviction or deferred sentence. And the staff recommendation is to allow Mr. Voss to sit for the Texas jurisprudence exam at his own expense once he has successfully passed the NBCE spec exam at his own expense. He is here if you have any questions.
Dr. Voss, I would love to hear from you. And instead of us putting this to a vote, could you come up and say hello?
Greetings.
Thank you for your service in protecting our country and our liberties and safety.
Questions?
Any questions, board members?
What brings you to our great state?
I've been in and out of Texas several times, obviously being former military, and what brought me here this last time.
Turn your microphone on there, Mr. Wallace, thank you.
Hit the button.
Push that.
There you go.
There we go. What brought me to Texas in 2018 was a job opportunity. I was working for flight safety here in the Dallas-Fort Worth area as an instructor pilot.
Gotcha. And now you're ready to get back in the trenches.
Yeah, you know, I turned 70 this year, and it's getting a lot harder to find flying jobs. Yeah, I've had an eclectic background. I love chiropractic. I love what it does for people. I've helped a lot of people. And realizing that the curtains are closing on my flying career, I decided to go full-time into chiropractic work, helping the members of my community, which is growing like a weed down there in Clayburn, or up there from here. Neighborhoods are popping up all over the place, and they need other chiropractors.
Can I ask when the last time you were able to practice chiropractic was?
That was when I was in Washington, and that would have been, I was there from 2010 to 2017, and I can't remember exactly what year I got my license there. The opportunity that I thought was presenting itself was I was flying for an individual who had his own jet.
Yeah, I read your.
His own company. And they were talking about having some kind of health for their employees at their base of operations. And I talked to them about, hey, what if I get my license and work, 2 jobs for you? And it never materialized. So I didn't actually practice in Washington. I held a license, but didn't actually practice.
Okay, so that was 2010. So 2010 was the last time you were actively practicing, or before that?
Probably before that. It was 20. 2007 to 2009, I think.
Okay. So around '09 was kind of the last time you were in active practice?
Yeah.
So the board could require you to take a competency exam as well. Can you, can you give us a reason why you wouldn't have to do that? To kind of describe your, if it's been, what, 16 years then since you practiced? I think that's what our concern could be. Describe how you feel like that your clinical skills are current, your knowledge and skills are current and would.
It's still in there. I would have to say that I fly, and it's been, like I said, in and out of the flying job. Every time I've gotten back into a jet, it's like riding a bike. I have no doubt. I've always been confident with my hand skills, and as far as adjusting is concerned. I have no reservations about what my ability is to help others with this great profession.
Can I ask what kind of practice you plan on starting or joining?
sorry?
Or what do you plan on doing practice-wise? Have you thought about like what that looks like? Are you
Well,
gonna-
I've actually maybe prematurely started looking at office space there in Claiborne just to see what's available and how affordable and that kind of thing. So my intent is to start a solo practice.
Hang up the shingle and go with it.
Yeah.
Are you planning on cash type practice, or
I'm sorry?
are you planning on like a cash type practice, or are you looking more insurance
I've
based?
had to deal with insurance companies before, and I prefer cash practice. I have no problem giving them a super bill. As far as I'm concerned, that's a private relationship between the insured and the insurance company, and them deal with that. That's my intent. We'll see how it goes. I'm not opposed to billing insurance companies that I've done in the past, and you all know what pain that is. Trying to get paid from somebody who says, "Oh, we don't need to pay that." It's like, technically you do. I've had to write many nasty grants to insurance companies. When I was practicing in Wyoming, I had a dedicated Medicare biller. I mean, that's all they did, was bill Medicare. And my Medicare patients still weren't getting reimbursed. And coming after me saying, "Hey, why am I not getting passed?" Well, you're going to have to talk to Medicare about that. I mean, that's why, if able, I'd like to stay away from insurance. Just my preference.
What's involved in the competency test?
It's case history, physical examination, neuromusculoskeletal examination, diagnostic imaging, clinical and laboratory specialty studies, diagnosis and clinical impressions, chiropractic techniques, supportive interventions, and case management. So all of the complexities of practice beyond like subluxation removal is what it kind of leans into. So I guess one question I have is, would you consider yourself more of a straight chiropractor who is going to come in and just do? Okay.
Yes. I graduated Life University and pretty much straight chiropractic.
Yeah, I have less concerns.
How often do they offer spec?
Every
year.
You took it.
It is.
Oh, you already took it?
No.
No, he didn't take it. No.
The spec is coming up. Unfortunately, yesterday was the registration deadline for the June test. I'll have to take the test in August.
Okay.
Their next offer.
It's 6 times a year.
Okay.
Major issues.
Yeah, I mean, just personally, I would be more comfortable if you took spec. It's been a while, since you practiced. I'm in active practice and always have been. And if I take, I just got done with surgery rehab and was out for 2 months. And I mean, it takes some time, even with a short period off. And I understand the flying and your competency. I think from a board perspective, though, and from my perspective with enforcement and being the chair of enforcement for the last 11 years. It's a public safety issue. It's not about you. It's about us making sure that we cross our T's and dot our I's and make sure that we're doing right by the public that's going to come see you. So that's just my personal opinion. If we have a different avenue other than spec to rectify that, I'm fine with that. But I would like some type of.
I think Part 4 would be the other avenue, and that's much more invasive.
Yeah, no, I don't want to
So
do
I
that.
think
I
spec's
don't wanna
probably
do
the
that.
least invasive, but still
I've already
covering
passed
it.
Part 4.
Yeah.
Yeah,
I think it's a time. You know, I think in
Passed all the
2021,
boards
looking
first
at
time.
this, that's probably why they required it in 21.
Yeah,
That's probably what we're going to.
Yeah, and unfortunately, I just,
Okay.
Whatever you-
that kind of
whatever
hit me
you're comfortable with.
broadside when I was
Okay.
presented with that. I wasn't expecting to have to do another national board. I wasn't prepared for it at the time. Financially, they want $1,500 for that test. I'm like, holy cow.
Okay.
For spec, they do.
So, I'm in a place now where I can do that.
I think so.
Satisfy the board requirement for respect.
Is there
Yeah.
any refresher course or something that you can come to speed of
Yeah.
practicing today?
When's the last time you did any continuing education courses?
Gosh,
Are you thinking of like acquiring a certain number of CE instead of spec?
Yeah, but if we do the CEUs, it's gonna cost the same
That'd be a lot
amount.
cheaper.
Everybody is.
I'd say like 30 hours for regular speed.
Yeah, so every licensee has to take at least 16 hours of continuing education before renewing a license. Perhaps that would be more appropriate.
Except for their first renewal.
Excuse me?
Except for the first
Except for their first renewal.
when they're fresh out of school and just
Okay,
finished.
our
hundreds
rule
of
is that
hours.
it's not required. Okay.
Also,
so-
the rules and regulations have changed in 16 years.
And I think jurisprudence will cover rules and regulations.
I think so too.
At least, so you'll have to pass the jurisprudence exam regardless. And so I'm not as worried about you being up to date on our board rules. It would be more like insurance guidelines, treatment plans, EHRs. I think about what was in place in 2009 that's totally different now, and a lot of that side's changed. But again, if you're
We
going
don't
to
need
do a
to
straight
make it- yeah, we don't need
subluxation-based
to make it
practice,
directly on
there's
JP,
a lot
just gonna
less
have to take the
complications.
JP license.
yeah,
Yeah.
So
like to keep it simple.
that's
I'm old
redundancy.
school, so.
I think the problem is that
hearing
once
we
we-
talk about,
once we don't
records,
cover our
So we
bases
just
if
need to
something
decide
does
just
happen,
expect
we have to show
Sure.
that we at least tried to
Move to allow
prevent
them to
that.
sit
So
in jurisprudence.
the simplest, most straightforward is
Recommend that he
probably
take the
spec
review
exam.
course, maybe not.
Yeah.
There's probably some combination of
Is there a
CE
course
that
for
we could
spec?
put together that would be,
A review course for
have to
spec?
be a lot of
Is there
diverse
anything like
CE,
that?
and that
I
may
think so.
take longer for you to
I
actually
don't know.
find than just doing the spec exam.
Dr. Bronson?
Yes?
I'd just like to say I still have a family to feed, so
Yeah.
the sooner I can get this done.
Yeah, I think
better.
for speed and efficiency,
Before you make the motion, Mr. Hollop had a comment or a question.
So I heard it earlier, so spec in comparison to doing continuing ed. What's the benefit
we would
to
have to
doing
really
spec over?
quantify the kind of continuing ed.
Yeah, it gets
So,
complicated.
You know, it might
Yeah.
have to be just plain 16
I'm
hours,
gonna-
it could be any combination.
Yeah.
It's just, yeah, it may not be relevant to his reintroducing himself into practice, whereas the spec would. As we talked about, that there is a cost to taking the test, and then the further lapse of time
How
where he.
quickly can you take the spec?
It's offered 6 times a year, so every
Yes.
August,
So if we approved it today, you could take it.
as soon as, yeah, the next,
It
it
would
could
be-
be somewhere between now and 2 months from now.
No, I think it would be in August.
It would be.
Yeah, I looked at the dates.
It would not be
and the next
between
one
now and then,
that's
it would be
Yeah,
then.
Offered
this way
is
it
June, but the deadline was yesterday. to
Ah, for the
apply
June
for
one.
that exam.
Yeah, so it could be August.
So we can do that test plus a combo of some sort of continuing education?
We could, but I wouldn't recommend that. The whole point of spec is for this exact situation, is to take someone who's been out of practice for a long period, make sure that their competencies are high enough to get back into practice and get back to it, so.
So that test would cover it too.
It's a broad test, it kind of covers all of the skills needed to be a Texas licensee.
How many years did you practice before 2006?
I graduated in '97, December '97.
So about 20 years, 97 to, yeah. Like 2000, no, actually.
No.
Not, only 13 years.
11 years.
11 years.
Yeah. So, I think I'm gonna go ahead and propose
Yes.
that.
I can kind of help you out.
Thanks.
So he first began practice in Colorado in 1998 is when his license was issued. And then in Washington, his license was closed in 2013. So
Yeah, and the alternative would maybe a restricted license, but I think you'd rather have just a free and clear license once you're in.
Be my preference.
Yeah, so I think to do that, we would just, I'd like to go ahead and make a proposal if we're ready,
Make a motion if you're ready, sir.
to approve staff recommendations of allowing you to sit for the jurisprudence exam as soon as you pass the spec exam.
Okay.
I'll second it.
Motion was made by Dr. Henry and seconded by Dr. Baucom. Any further discussion? All in favor say aye.
Aye.
Aye. Any opposed, nay.
Look forward to having you in the profession here.
Thank you very
Motion
much.
carries.
folks.
Welcome to
Appreciate it.
Texas.
Thank you for your service.
I'm gonna step out for a second. Just rest.
Okay, Dr. Baucom's going to step out for a moment. Would anyone else need a break? Oh, sure, I heard. So it is 9:52 a.m. and let's take a 15-minute break and reconvene at 10:10. Welcome back, everyone. The date is May 28, 2026, and the time is 10:12 a.m. The board will now reconvene in open session. The next group of agenda items pertains to matters of enforcement. Agenda item number 8 calls for discussion and possible action on proposed final decision orders pursuant to Texas Occupations Code 201.555 and 22 TAC 81.10. We have none for this meeting. Agenda item number 9 calls for discussion and possible action on proposed cease and desist orders pursuant to Texas Occupations Code 201.6015 and Texas Government Code 2001.056. We have none for this meeting. Agenda item number 10 calls for discussion and possible action on default orders pursuant to Texas Occupations Code 201.555, Texas Government Code 2001.056 4 and 2001.058 D through L and 22 TAC 81.6B. We have none for this meeting. Agenda item number 11 calls for discussion and possible action on proposed agreed orders pursuant to Texas Occupations Code 201.504A1. We have none for this meeting. Agenda item number 12 calls for discussion and possible action on required suspension or revocation of licenses for certain offenses pursuant to Texas Occupations Code 201.5065. We have none for this meeting. And then next on the agenda is a provision for board policy discussions. Agenda or items listed under this heading include topics which have, for various reasons, become worthy of discussion. And this is a way for us to share information openly and with each other. Our discussion doesn't necessarily warrant any rulemaking. The board may discuss but take no formal action on these matters. The board may direct the staff as a result of these discussions. Our agenda item number 13, our discussion topic today is TBCE's strategic plan, and I turn this discussion straight away over to Dr. Bush.
Thank you, Dr. Bronson. I appreciate it. Every legislative session, leading into it, we have to review our strategic plan, and we have to come up with modifications, other changes, and of course with the horizon in IT and AI and all those kind of things, it warranted a thorough discussion this year. So we stood up a committee so that we could discuss the options that we had. We've reviewed it. Unfortunately, the LBB sent out instructions later than normal, so we had a very quick turnaround, but we had a very robust discussion. And we have some things that we've modified slightly from our last strategic plan and added a couple of nuances that are going to make it a better plan. And also involved with this is every time we must do a customer satisfaction survey. And we, unfortunately, because we didn't get instructions until later than normal, we had the window open a shorter amount of time, but we were able to get the information back before this board meeting, and I've included that as a supplement. That's what the handout is, that's got the little bar graph and everything. That's the customer satisfaction survey. And so that will be added back into the strategic plan before we actually turn it in, which is due on June the 1st. That's why this is a perfect time to go through this. So in your packet, you will find the actual draft of our strategic plan. And looking through it, it's similar in structure and information from previous years, because a lot of the things we continue needing to address, some we've corrected. So if you will look with me, all the way down on part C will be the first place where we'll really start to talk and go through this, which is page 6, redundancy and impediments. Some of the changes that we looked at, budget and transfer authority, that's been consistent over the years. Duplicative fingerprint, that's the same. Criminal penalty for unlicensed practice is where we're going to first start. So that's number 3. Right now, this ties into the fact that if you practice chiropractic without a license, that is only a misdemeanor offense. And as a result, we may go through the process, get a complaint, find out the information, do investigation, and we find out that someone truly is doing that, then we go to local law enforcement to get their help. Unfortunately, because of the overburdened caseload of all law enforcement agencies, they don't have a tendency to want to go after misdemeanors. And so as a result, they say, we appreciate it, we're glad you're looking into this, but in most cases, we are not going to get any help going after the individual so that we can get that misdemeanor enforced. And so therefore, it ties our hands on what we can actually do. The medical board has a felony conviction involved with their practicing without a license. And so our goal last session was to get that changed. We did not meet with success. However, fortunately, the TCA is helping us with this, and other folks are involved as well to make a campaign so that we can get that straightened out. Because if somebody is practicing without a license, likely the reason is that they are doing fraudulent activities and are going to hurt somebody. And so we've got to protect the state that way. And so we put that in here as something that we need to address so that if it's in our strategic plan, we are notifying the legislature that this is a problem and we've got to have some help with it as well. And so it's part of the big package that we're putting together to try to move forward and get some changes made. You'll notice there the language kind of lays out what I just said, and the fact that the estimated benefit, stronger determined against unlicensed practice, increases cooperation from local law enforcement, enhanced public protection. So what this does is it allows us, if we were to receive the felony conviction, that would allow us to be able to get the bad actors out of the way. And so that's one of the items that we kind of updated from the last session to really emphasize what we need to do there. Are there questions on that component as we move forward? That's specifically for unlicensed practice. Number 4, cease and desist orders are pretty cumbersome on what we want to do to try to stop these bad actors. And so this modifies the estimated benefit. Faster response to unlicensed practice, enhanced public protection, reduced period of public exposure to unauthorized practice. So this is another tool in our arsenal to be able to attack those that are not that are fraudulently practicing chiropractic. Questions on that? And number 5 is one that was already in the previous strategic plan, basically streamlining what our rules have to say and make sure we move forward. Number 6, definition of practice of chiropractic. Again, this removes unintended barrier for chiropractors in legitimate non-clinical rows, reduces frivolous complaints, aligns definition with actual scope of practice. So this is more of a cleanup request that we are putting in here we're wanting it to clarify. And then liability, number 7, is one of the main ones that we changed as well. This one's interesting. Right now, no current provision requires a person or business entity to register their ownership interest, business structure, officers, and so forth, agent in a business providing chiropractic services. Basically, what this is saying is chiropractic owners of clinics do not fall under our jurisdiction if they are not a chiropractor. And so myself, not being a chiropractor, if I own a chiropractic clinic and I'm having practices that are against statute and against chiropractic rules, there's basically all the board can do is issue a cease and desist letter. They don't even, it's not even a particular order, it's just saying basically you can't do this. And if I don't comply, the board has no teeth to do anything about it. We have to have local law enforcement to be able to move that forward. And correct me if I'm wrong here in what I'm saying, Rudy, but we need more. That's where, again, this is part of our arsenal not just chiropractors people doing the chiropractic, but there are owners who are prescribing and saying you must do X, Y, and Z with your patient regardless of what they present with. And so that in and of itself is someone that is not a chiropractor directing chiropractic procedures. And so we need some way to be able to hold them accountable for the wrong actors. And so that's what we are seeking, and that's why this is in our strategic plan. Again, to strengthen what we do to protect the chiropractic profession. What we are seeing are these young chiropractors coming out of school, going to work for different firms, I'll put it broadly as firms, and are giving, say, every patient, regardless of what they present as, you must do X, Y, and Z. That is, by definition, practicing chiropractic without a license. And so we can't do anything about it because we don't have any strength in our statute in order to give us a strength. So that really kind of rounds that out. And I hope I hadn't misrepresented that, have I? No. Okay. I always lean on my attorney over here. That's why I married one.
I did want to add one thing about non-DC donors. Another issue that we do see is patient records and who's in charge of those patient records once a DC leaves a firm, you know, and so that is something else that will help us to kind of figure that out as well.
Exactly. So those are some of the redundancies and things that we wanted to address in there. Are there questions on those? I'll be happy to field any questions. All right. Moving forward then, there's nothing, you won't find anything different much after this except the historically underutilized business section has been removed because they have changed that requirement. And so that's not in this edition of the strategic plan. Last strategic plan, it was there, so where it's no longer a requirement. Performance measures are all tied in much the same. And then if you'll go down to, let me get the right page here. My finger didn't move very fast. Come on, there we go. It's toward the end of the document. Here we go. See, here we go. Here we go. Now, page 23, report on customer service. You will see a handout that I've provided for you. This is a breakdown on the questions that the Legislative Budget Board requires us to have asked and give an analysis of, and that is going to be included in the final version of the strategic plan that we turn in. And so I gave you these as an update for you to look at and see where we stand with, and for the most part, it's pretty consistent across from last strategic plan to this one. And so it's looking pretty good. Again, it addresses some issues that we will look at to try to enhance for the next legislative session, but we've already addressing several of these needs, especially from an IT standpoint. And as you look through those, I'll give you a moment just to peruse those. And those, again, will be added to the strategic plan. What you see in the strategic plan are those from the last strategic plan. And you can compare the numbers between the two documents very easily this way as well. It's basically the same questions. Again, I have to turn this in on June the 1st. I will, actually I've already updated the document to reflect these numbers anyway. So that way I'm ready to turn it in. Yes, Doctor.
So once you turn this in, and I know TCA is going to try to run with the felony status, but does this committee, when you turn it in, do they have any ability to accentuate the, how am I trying to say this?
To look at our measures and use it as a catalyst of, hey, we need to write some legislation.
Right.
There is no requirement that happens, and there's no requirement even necessarily.
But that's your goal with this.
That's my goal.
Okay.
And the second half of that is, if I'm a young legislator, I guarantee you I'm going into every state agency looking at these things, because these are easy pickings. Because I can go, the goal of a young legislator is to say, I got to get some bills passed. And I can go through these strategic plans at different agencies and find out some things that need to be addressed, pick those up, get the legislation through, and I've got home runs all the way through.
Okay.
And so if I was advising a senator or a legislator, which I've done, that's exactly what I tell them to do.
Okay.
So, yes. I see Dr. Henry's got something. No, okay. Questions, concerns? All right. Well, my intent is to get, and I don't know, there's not an actual process to say I can't turn it into you approve it, but I do want the board's approval to be on board with what we've proposed here as well. So how that takes place, different boards have reacted different ways for me. So, but I wanted to present it to you and get your input and feedback.
Thank you for putting this together. I think it's well structured. I think it addresses all of the concerns that I might have. I can't speak for the ones that I'm not thinking of right now.
Well, you got 2 years. We got another. We'll do it again in 2 years.
No, look good.
But yeah, thank you for listening to the public. Thank you and board members and for trying to make the world a better place by presenting our strategic plan and perhaps getting some legislation that supports our mission.
That's our goal. Yes.
Yes.
Absolutely. So if the board does not have any reservations, I will then move forward with this document and turn it in as our strategic plan for the next 5 years.
Do I need to make a move?
Right. Well, this being a discussion item,
Mhm.
I'm instructed that the board doesn't take any formal action on it, which would be a vote.
You can
So-
do a vote of assurance.
Vote of
That's not legally binding in any stretch.
And we could also just say if there's any additions or anything you'd like to discuss. If there's not, then the silence would be, and the no discussion would be approval for him to be able to move forward.
I'd go as far as directing them to go ahead and submit that.
I agree.
Looks well.
I think that we can do that too. So without any
Concerns
opposition,
from the board?
the board directs you to submit this awesome strategic plan.
Agreed.
Thank you. I
Agreed.
appreciate the board and I appreciate you, Dr. Bronson. So.
The next couple of agenda items are rules for proposal. Agenda item number 14 calls for discussion and possible action on proposing the readoption of board rules in chapters 71 through 74 as part of the quadrennial rule review process. Rudy, would you like to comment on this?
Yes. Thank you, Dr. Bronson. So we are required every 4 years to go through all our rules to clean up any superfluous rules, repetitive rules, anything that needs to be addressed. Not necessarily substantive, but if there's a common missing, things along those lines. So we are proposing chapters 71 through 74 in bulk. That starts our 4-year clock ticking. So during this time, over the next 4 years, we will be looking at chapters 71 through 74 for anything that needs to be cleaned up. I do know that we will most likely have things next board meeting for proposal that are within that chapter structure. We will also have the next batch of chapters ready to go for proposal at the next board meeting as well, and then the final batch the board meeting after that. And so that starts our 4-year clock ticking for each one of these batches, and we can go in there and start looking at those rules and see what needs to be cleaned up.
Thank you for that advice.
Any discussion?
Well, I'd entertain a motion, unless you want to discuss it first. I'm fine with that too.
I would like to move that we go ahead and propose this rule batch of 22 TAC chapters 71 through 74.
Second.
Motions was made by Dr. Henry and seconded by Dr. Neal. All in favor say aye.
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 Any opposed, nay. Motion carries. Agenda item number 15 calls for discussion and possible action on proposing the amendment of a rule relating to business practices, 22 TAC 75.5 prepaid treatment plans is the current rule and the current heading of that rule.
So I can give some history, or
You want to take?
Please, Dr. Henry.
Dr. Henry.
So we started approaching this rule back in, we were trying to remember when we did our first stakeholder meeting on this, and we were thinking it was probably 2021. So this has been a long ruling process. One of the big glaring issues we saw was that this rule only addressed prepaid service packages and none of the other membership models or prepay models available as far as wellness plans, membership models, concierge practices. And so we wanted to create a rule that gave our enforcement committee a little more oversight over other kinds of business practices. So the new title on this you'll see is financial arrangements and prepayment of services. It does still keep a lot of the language from the prepaid rule, but it expands that to one, other persons, so not just licensees. It expands that to other persons as defined by government, which can also be entities. We added in all of the other types of models that we thought of, and this is going to be our first shot at getting this out to the public for comment. So, yeah, I think it'd be definitely a rule open for discussion. We'd love to get feedback from other board members and kind of go from there.
First and foremost, I really like the title that you guys did. I think that really helps. The only thing that what I've heard in the past out kind of in the public domain is some of these models, like if a patient wants to cancel it, they will not let them cancel unless they come in by person.
Yeah, Dr. Bronson brought that up, and before we vote on this, I'd actually like to edit the language a little bit so that even what we propose out to the public will have a little thing to address that. So by any reasonable method, I think covers that. So those are the kind of feedback I'm really looking for is what are the biggest challenges you have, and then hopefully as we get some public comment on this, we'll be able to improve it even more.
Thank you.
Make a motion.
Before you do, on if you look at C3, which would be the arrangements that must be included in writing for any of these agreements, 3 says a cancellation policy allowing the patient to cancel at any time for any reason. I would like to add the words by any reasonable method without penalty. So just before we vote on that, Rudy, if we can include that in what we propose to the public, that would be a start. I believe we have some comment on this from the public that you asked to speak on this rule. Oh, sure. I mean, up to you, Dr. Bronson.
No, thank you for reminding me, Dr. Henry. And let's hear from Dr. Scott.
Dr. Scott Kelly, representing myself and the Chiropractic Society of Texas. Specifically on the one that you were just mentioning, I was wanting just clarification on what...
Is your microphone on?
I believe
your
so.
Okay.
Yeah.
Normally you're so loud.
Sorry. With the without penalty, can I get a little clarification on penalty? The example that I would have is if this is considered penalty, say you are doing a package of X amount of visits and you discount by prepayment by $5 per visit. If they utilize 2 of those visits, say, hey, I moved, blah, 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 is penalty considered if you now include that $5 because again they were buying it in bulk, and just some clarification on
Yeah,
that.
so that's the most common question we get on this, I believe, is bringing your price back to your regular price a penalty or not? And I think that the way enforcement treats it is that your normal prices are not a penalty, you just lose the discount. And as long as that's documented clearly, that is my understanding on how enforcement interprets it. That's definitely how the rule was intended. Is there any clarification from enforcement on that?
From my understanding, what you're saying is, if you sign up today, you're giving a discount, correct?
For buying a bulk package.
For buying a bulk package.
Correct.
However, if I leave early, you're gonna charge the full price as a penalty.
Well, you lose the discount. There should be no
You lose
penalty.
the discount, but you have to pay full price. So pro rata, you're giving back less money.
You're giving back, yeah, so you go back and rebalance the books based on that. And that's just legal advice from previous enforcement. Is that how we're treating it currently?
What way we treat it is the amount that was paid and what you used, pro rata is what you're gonna get back.
Well, I think we need to clarify that in the rule then, it sounds
I
like.
don't think there's a way of putting a penalty on somebody because they didn't use the package.
Well, you can have a cancellation penalty, but we're preventing that. So
Yeah.
some documents in other industries have a cancellation fee, which is a penalty. So this was written to prevent that,
Right.
not losing a discount you got, because if you bought a package and didn't complete a package, well, you don't get the discount for those. You just get the normal price for those.
So
Otherwise, everybody would just start a package and cancel halfway through to get a
Yeah,
discount.
I would discourage that.
Okay. Well, then we need to I think that's an area that's gonna need some clarification to make sure it's in rule.
So that was the only question I had.
Yeah.
That would be an appropriate comment to
Yeah.
make during this proposal. So that during the comment period that will begin after this is proposed and sent to the Texas Register proposal, we can take comments in and modify based on those comments if we find them necessary. So
And I would encourage the public to, I really want to get those, because there's so many business practices out there that we're trying to just clean up and not make it overly prescriptive, but still just set some guidelines as to what's fair to the public.
Right, and
So I think defining penalty probably needs to be done. That's helpful.
That's what I said. We don't disagree with anything in the rule. I was just wanting that
Yeah.
clarification. So,
Thank you.
Appreciate it.
Also, may I ask on this rule, is there a way of defining membership as well as prepaid treatment plans? Is a membership a prepaid treatment plans?
I think that the way this rule's written is that should be included in here. Is it a membership?
Because that's what I'm facing now. Right now, I'm waiting on a response because we've had the joint respond back that we have no.
Currently, it's not. Currently, membership model is not addressed by rule. So that's why this rule is so necessary, is that membership models across every industry have expanded. Repetitive payment models, subscription models have expanded dramatically, and we have a rule that's behind the times on that. So currently, no, it doesn't apply. With this rule, it should. So having guidelines as to what is included in those memberships is what I'm looking for. So
Yeah.
enforcement, as you read this, if there's something missing on this list, comments are great. I love the feedback. Great. Thank you.
Dr. Neal had a comment.
I also would like to address a kind of a lopsided type like discount program. It's like they'll say, well, your initial visit and your first.
Yeah, your last one's free.
Yeah, well, no, not necessarily that. That is a problem, but it's more of we're going to give you this brace and we're going to do this massage and we're going to do this all on the front end of it, and this is $4,000. And then your next 28 visits, we're going to discount you this much. But they don't ever make that clear.
So I think that's one of the big things we wanted to clear up, was to make sure that these financial arrangements are clearly disclosed, that they go through any durable goods that are included. As you can see in here, durable and tangible goods, the prices. And so if you read this and you feel like there's language that could be cleaned up, that's the kind of feedback I'm looking for. But that was kind of the purpose. I was very aware of the $2,000 brace and the $4 adjustment. Well, what do you refund then at the end? And so as long as it's very clearly written out, and enforcement will be able to read these agreements, because now they're required to have it in writing, they can decide if that's ethical or coercive or deceptive. So the goal is to give you guys a little more leeway while still just kind of setting guidelines and letting businesses and patients decide what they want to agree to.
Is there a way to include in the language that for any reason, if your cancellation would essentially give you X amount for, per canceled visit?
So the way that these models are so different, it's really hard to be very prescriptive on that. So if it was just paying for like X number of services for X dollars, we could do that. Because we're talking about memberships, we're talking about concierge where you pay $1,000 at the beginning of the year just for access. We have so many different models here, we're just going to have to define what has to be included in the documentation and then leave it up to enforcement to decide if it was ethical, deceptive, misleading, or coercive.
Well, to clarify, so, I know that there's a front-end administrative cost to doing business, obviously, so some of that's going to be given. So I understand that we can't break it down evenly per month.
Sure.
I understand that. But past that, if there's a way to mandate that clarification in the contract, so that way if there was a cancellation that came to us, then we simply look at the contract and we would have Rudy and his team go through it, and we could dictate based on that contract that they entered into. Is there a way to just mandate that requirement?
So most of the questions that I think are going to come up the most are cancellation policies. So I think there is some room for improving that subsection of C, is that what we want in there is a clear cancellation policy. So there may be some more definition we could put to that. I don't have the language right off the top of my head for that, but I think that's the direction we're trying to go.
That would help.
Yeah, that would be awesome.
I would make a motion that we send this out for public comment with the revision given to C3 as we discussed.
I'd second that.
Motion was made by Mr. Holub and seconded by Dr. Henry. Further discussion or clarifications, anyone? All in favor, say aye.
Aye.
Aye. Any opposed, nay? The motion carries. Thank you.
Place to stick that.
Give you all a minute to make your notes.
A clear definition of kind of what we're trying to accomplish here, so I think we could find some.
Tell me when you're ready.
I'm ready.
The next couple of agenda items are rules for adoption. Agenda item number 16 calls for discussion and possible action on adoption of the amendment of a rule relating to board fees, which is 22 TAC 72.1 fees. We can start the discussion either with Rudy or Dr. Henry, and I think Dr. Kelly, did you want to comment on this one?
I don't think so.
No? Okay.
Yeah, this is just the 22 Texas Administrative Code, Section 72.1 fees. This is up for adoption. These amendments they are laid out in front of you as they will appear. So this, I will defer to Dr. Henry and his knowledge of the process of this one, since it goes back further than in my tenure here.
I believe this one was mainly cleanup. I'm trying to pull it up right now. Yeah, this was just an amendment to clean up the fees for our services to match what we're charging online, I believe. Do these fees still match? I mean, I haven't checked this against.
Yes.
Okay, yeah, this is just cleanup. I would just move that we adopt this one, it is up for adoption, that we adopt
Yes.
this rule, making a motion to adopt.
Second.
Okay, motion was made by Dr. Henry. I did hear a second by Dr. Wofford. Any further discussion? I do recall going over this a long time ago.
Sorry.
So all in favor, say aye.
Aye.
Any opposed, nay? Motion carries. Agenda item number 17 calls for discussion and possible action on adoption of the amendment of a rule relating to license applications, 22 TAC 72.3 qualifications. And so I know Dr. Kelly, you signed up to speak on this, and also Dr. McGuire. Dr. Kelly?
Dr. Scott Kelly, representing myself, Chiropractic Society of Texas. I know this rule is the typo that's been sent back to the SOS, I think about 4 times. My comment is the same as previous, to consider removal of CCE by name and just a DOE approved agency. Then if it is going to be CCE by name, the potential addition of IAC.
Yeah, I know that we'll have to go back and review statute and make sure that we're consistent with that. I appreciate your comment. Thank you.
So this amendment was a cleanup of some names in C, 72.3C. It removed the word international from Councils on Chiropractic Education International. It was repetitive. It showed up in both places. It should be Council on Chiropractic Education, Council on Chiropractic Education International. So there was 2 internationals. One was removed from the first Council on Chiropractic Education. There was also a handout that was given because the typo of an S was changed from Council on Chiropractic Education and Council on Chiropractic Education International. There was typo, one S went on one council when it should have gone to the other council. So we all have a handout of a typo as a non-substantive change, just to clarify where that S should go. So for the rule, it will be Council on Chiropractic Education or the Councils on Chiropractic Education International would be the final language.
So in this current form, this rule is just cleaning up the actual language and names of these institutions.
Right, and the substance of the rule can be put on a future agenda, as a
Correct.
future agenda item. Dr. McGuire, did you want to comment on this?
Thank you. Am I on?
Yes, you are.
So I'm Cecilia McGuire. I am the Dean of Academics for the College of Chiropractic at Parker University, and I'm here representing myself and the College of Chiropractic at Parker University. I also should disclose I am on the CCE Site Team Academy, so I'm not a member of the actual council, but I just wanted to disclose that.
Thank you.
So there were two things I was going to mention. One was actually under B, about the hours being transferable to the University of Texas at Austin. And this is not me as an Aggie saying this. This is me as a dean of a chiropractic college, that often that becomes problematic for students who, for example, went to, let's say, Dallas Baptist University, and they got a degree or they got their 90 hours in religious studies, things like that. And so I just would advocate for removing the requirement of them being transferable to the University of Texas for that reason. And that's all I had to say about B.
I remember there's a statutory.
Does that make sense?
It does make sense, but I believe this comes from statute.
It
And
does.
it does, so this would require a legislative change, and it's something that could be put into our strategic plan if we so desired, I guess. But that's the route that we would have to take if we had anything to do with it.
Understood. I just wanted to make sure my
Yes,
concerns
thank
were.
you.
Keep reminding us that, but yes.
Thank you. Has nothing to do with being an Aggie.
Sure.
By the
It
way-
hasn't come up recently with
Sure.
anyone, but when it does come up, it seems to be around religious studies and things like that. We're looking for well-rounded students, and we would accept those into our program, but then it becomes an issue when they go to get a license in the state.
Yeah, there's a statute reason why I think
It's
that
a
a lot of,
workforce committee. I mean,
a lot of statutes reference the University of Texas,
Corporate
and it's just that's the
education.
standard for like what is considered hours in the state. Academic hours.
But what now?
I could be wrong, but I believe that statute came from it's from the Co-Board that states that, is it not? Co-Board of Higher Education?
I'm not sure. THECB, the Texas
Coordinate,
Higher
yeah,
Ed
yeah.
Coordinating Board.
The Co-Board, that's in their language that I've read before, that's transferable to UT. I think that's where that came from originally. That's probably why it's in our statute.
We might consider adding something in parentheses, hook 'em.
Oh, no.
Got a lot of longhorns.
Oh.
I would add
That's
that
true.
perfectly
Yeah.
legal.
Think about
Gonna have
All right, so I propose that we adopt this amendment without changes.
That was a proposal. Did you have further comments? I think you did.
I
didn't
did,
you?
and it
sorry.
was on the part about the Council on Chiropractic Education. I noted the same thing you did about the singular plural nature of CCE versus CCEI. But I just wanted to point out that it says it's a member of the Council on Chiropractic Education, and I don't think there are member institutions there, and so we might need to clean that
I
up.
think you're correct, yeah.
Yeah,
I think-
that's on our radar for the next board meeting, to try to clean that language up.
Yes, we're going to make that technically correct.
Dr. Bronson thought he'd be the only one to catch that, but.
Yeah.
And not surprising, you caught it. Thank you.
Thank you. All right. So yes, I propose that we adopt these, the changes as proposed.
Second.
The motion was made by Dr. Henry, seconded by Dr. Neal. Any further discussion? All in favor, say aye.
Aye.
Any opposed, nay. Motion carries. The next two agenda items are legal matters, and I will go through this. Agenda item 18 allows for closed session. The board may meet in closed session pursuant to Texas Government Code 551.071, 551.073, 551.074, 551.076, 551.088, or 551.089 if related to the agenda items above as necessary, and we don't need to do that. Agenda item number 19 allows for closed session pursuant to Texas Government Code 551.074 involving personnel matters. The board has the right to discuss any agency matters at this time, and we do not need to do that. In conclusion, agenda item number 20 allows for any requests from board members for future agenda items. I know we had something.
Yeah.
And if we don't hear about it right now, that doesn't mean we can't have a future agenda item. But this is your opportunity to express.
Yeah, Dr. Bronson, I do from enforcement, and I've spoken to Rudy about this. We need to put on there a discussion about quantifying, registering, tracking diplomates in Texas, some way, shape, or form. I know how you feel about that. I know that.
Thank you for bringing that up. Yeah, so this is a public perception and
Right.
potentially a safety issue involving a common practice of misleading the public, either intentionally or unintentionally, that a person has bona fide additional qualifications.
Yeah.
And so we want to clarify that in rule. Licensees want direction. They want specific guidelines on things. They need it. We need to do it.
It's a public, but from enforcement, it's a public protection issue though too, because we have a lot of, or not a lot, but it's becoming an issue because there are so many diplomates, and there are some that there's different qualifications for all the different diplomates, hours wise and education standards wise, advertising wise. We don't really have anything in place where we can track diplomates. Are they real? Are they advertising within what they're capable of doing with the diplomate? There's a lot of stuff. And especially with the rise of multidisciplinary practices, when you have a chiropractor that has a bunch of extra letters behind their name, it can be misleading if there's no.
Is this an advertising rule that we're looking at?
I think advertising is part of it.
I would also say it's a rule, Chapter 72 rule as well that we need to look at.
So, anyway, I sent some info to Rudy this morning just to kind of get it started, but I'd like it as an agenda item.
Or at least a discussion item, yeah.
Correct. Yeah.
As a discussion item
Yes.
for the next agenda, based on that, there could be future action by roll.
Okay.
But it gets the discussion going at the next board meeting.
Yeah, it'd
Yeah,
be
so
nice.
first it would be a discussion item, and then if we can draft a rule, then it would be proposed in the next meeting and then adopted in the next meeting. That's as fast as it can get.
That would be the quickest it could go. If we wanted stakeholder input before we draft the rule, we could go that route as well. So there's a couple of different routes, but the first step is to have a discussion about it at the next board meeting, and then based on that, we would have some steps after
Hopefully
that.
get some public comment on it if we have it as a
Yeah.
discussion item, and then we can
If
get
it's-
stakeholder input.
I agree.
If
I would
it
like-
is published, then the public can come and
Yeah.
talk about it at the same time that the board's
That would be
discussing.
great.
I
Efficient
agree
public.
to open it up for comment as early as possible, and so everybody can weigh in on this. Anything else?
Got this one.
Agenda item number 21 allows us to adjourn the meeting.
Moved.
Mr. Joshua Holub made the motion to adjourn, and Dr. Wofford seconded the motion. Any discussion? All in favor to adjourn signify by saying aye. Aye. Any opposed, nay? The time is 10:56 a.m. and we are adjourned. Thank you, everyone, for your input and your attendance.